Okay, we're going to get started up, everybody. Thank you so much for coming to what is this year's final Faculty of Law Research Series presentation. And so just as a very brief introduction, I'm not going to take too much time. Well, first off, before I do that, housekeeping, there's food at the back. I see some of you have already found that, which is fantastic. Please help yourself to whatever types of baked goods and fruit and coffee and tea there is, or there are. And then just to introduce our speakers for today, I'm very excited to welcome our Professor Brad Morse, as well as his research assistant, Simran Joura, who are working on a project together titled Indigenous Governments and Local Government Relationships Across Canada. This is extremely timely research as we continue to work through how to best reconcile relationships between our Indigenous population and the rest of the population of Canada. So very excited to hear what they've been finding. I'm not going to take any more time. I'm going to let them introduce their project and talk about it. So please join me in welcoming them to present.
Brad Morse West. We all have the pleasure of being on the unceded territory of Secwepemc Nation, Secwepemc Wulu, and pleasure to see you here, and to welcome our dean back. I'm not sure when you got back, but it's delightful to see you here. So I assume just recently. So let me first off express my appreciation to the Law Foundation of British Columbia. They gave a grant for this project in the, I guess, November of 2020 that enabled me to hire Simran as a research assistant last summer and continue her working in this regard as well. And also, it provided funds for us to just cover some of the logistical costs, et cetera. And the Law Foundation very kindly gave us a second grant this past November for this project, because the more we dug into it, the more we've discovered the huge number of agreements that are out there. So the overall purpose of this research project, as kind of the title indicates, really is to, is this going to be a down button or no? Nope. All right. Yep. Oh, there's a little arrow in the corner. Okay, really tough. Yep, and it's getting a life of its own now. Okay, there. So, and part is triggered just by an appreciation of the remarkable, long-standing, positive relationship between what was then the Kamloops Indian Band and then the town of Kamloops that has continued to build and strengthen over the years. The very first agreement between them was in 1965. And for those of you who've gone over the Red Bridge downtown, you arrive in what is the Mount Paul Industrial Park. You're actually on reserve land at that stage. And so, in part because of the geography of this city, there's not all that much flat land, particularly on our side of town, on the south side. And so, and what was part of early settlement and has been occupied and housing and so forth, and some commercial activity, but not industrial activity. And so Kamloops was wanting more space for industrial activity. The Kamloops had land that was a part of its reserve, divided by the highway, that was not actively used. And so this was kind of a wonderful partnership between them. The town had the experience of building paved roads and putting in water lines and putting in sewer lines underground. They had equipment for it. They'd done it for city land. And the Kamloops, to Secwepemc, didn't at that stage have much of that activity, particularly didn't have the infrastructure to build it. And so this was an ideal partnership between the two of them, in which the First Nation learned about property taxation, which is not something they'd ever done before on reserve. And they learned from the city about how they impose property tax as a way to cover the costs for building the roads and water and sewer on lands. Right? And as a footnote, this was all being done in the 1960s, then by Chief Clarence Jules. His son replaced him as chief, or Cookby Manny Jules. Manny Jules is the creator of the Indian Taxation Advisory Board. He pushed through amendments to the Indian Act that empowered all First Nations that are recognized bands, as the Indian Act language uses, to be able to pass tax bylaws and tax anyone on their lands. And so this built upon the 1965 agreement. And so they, since that power wasn't there at the time, they created a kind of equivalent to a property tax regime, which was service charges. And so to the non-Indian owned businesses on the Mount Paul Industrial Park, they pay service taxes to the First Nation, but in which the city is benefiting. So, of course, it brought all of those businesses you see there, all of which had people who now live here. And so it was a significant advantage to the city, even though it's on reserve land, because the city and all of its shops and so forth received the benefits of all of these new people who've come in. And so the city and the Tk'emlúps have had this relationship now going back to really the early 1960s. The agreement formalizing it is 1965, but it took a while to get there. They've had a number of other agreements since then. And so that gave us kind of a local story here that intrigued me, but I was aware of other communities doing similar kinds of things. There is some literature out there, particularly from the political science, social science side. From the legal side, we've got a couple of published articles on whether the duty to consult on the provincial, federal, territorial crowns applies to municipal governments. But that's really about it. On the other hand, we've had the Federation of Canadian Municipalities and the Canadian Association of Native Development Officers have worked now since 2013, so the last 9 years, on a community economic development initiative project whereby they invite applicants from First Nations and municipalities who've got some agreements to receive fundings to strengthen that relationship, and for external consultants to do an appraisal, a description of it, an evaluation of it, see how this arrangement has evolved over time. Union of BC Municipalities has absolutely been the leader in all across Canada in a provincial association of municipalities that has focused a lot of its time and energy on the relationship between Indigenous peoples and municipal government when they're urban people, but also, of course, in particular, between First Nations governments and municipal as well as regional governments, such as the Thompson-Nicola Valley Regional Development and Regional District. And so it's particularly appropriate, I think, that this research project be grounded in Tk'emlúps territory and in BC, but we're looking at this on a basis of coast to coast to coast. And let me turn over to my distinguished colleague.
Thank you.
Yeah. Which one is it? Not that one? Oh, not that one. No, oh, it is. That's actually that one. Talk about the press. A little bit of drama here. But it's a challenge to someone's on.
Okay, apart from that interruption, I'm sorry, but my name is Sim. I'm going to go over our research method for the project and share some of the data that we've gathered so far. So just to set the stage, one of the ways in which this project is very significant is when we look at the growth of agreements and the timeline of the growth of agreements between local and Indigenous governments across Canada, we see an insane growth spurt. Particularly in the last 2 decades, as shown here. This just shows the sudden increase in service agreements and relationship building type agreements due to new elements of truth and reconciliation being introduced, and also recently the United Nations Declaration on the Rights of Indigenous Peoples. This graph specifies the growth by provinces. Like Professor Morse said, BC is a clear leader in this area and has taken the lead in service agreements and relationship building type agreements specifically. What's interesting is that some of the smaller populations like Yukon have just as many agreements, if not more, than the bigger populations like Alberta. So when it came down to research methods, like Professor Moore said, a lot of the legal research was limited. We primarily have retrieved our information from public databases. Again, BC is a model example because of the UBCM, which has a public database of government reports, case studies, copies of agreements, news releases, etc. Something that we haven't seen anywhere else across Canada. Another public database that has shaped the foundation of our research was FCM and CANDU's case studies on community economic development initiatives. CEDI is implemented by both FCM and CANDU, which is a national organization that trains, certifies, and supports Indigenous communities across Canada in economic development. This program was built to help neighboring municipalities and First Nations find new ways to work together to collaborate on addressing regional issues and build a stronger, more sustainable economy for their citizens. The program itself is centered on a stronger together approach, which is a 4-stage process and takes about 2 to 3 years to accomplish. These 4 stages include having a vision, developing a plan, acting on that plan, and of course, connecting, having a vision, developing a plan, and acting. The demand for this program has exploded since 2013, and this just shows how many municipalities and First Nations in Canada want to work together. In terms of the impact that CEDI has had, there's an impact evaluation report that shows that just based off of 4 partnerships, this program contributes to significant long-term benefits, including almost $43 million in private investments, tens of millions of dollars in public investments, and almost $5 million in an annual increase in labor income and hundreds of jobs. We have also conducted interviews of key members in intergovernmental relationships from coast to coast, from Ontario to Saskatchewan to BC to Yukon and more. We have also conducted interviews of key members of provincial and municipal organizations and associations. So, for example, we collaborated with the rural municipalities of Alberta this past summer to develop a questionnaire that we could distribute to the key members of to all members of the association. This was actually really successful because it yielded many responses from all of our main members that have relationships with neighboring First Nations. And we're currently in the process of collaborating with other provincial organizations to do the same. So when it comes to the spectrum of agreements, I'm just going to briefly summarize the types of agreements that exist in Canada and the types that we found in our research. So service agreements tend to be the most popular, as you could see from the earlier graphs. These usually involve one party, that's usually the municipality, that provides services to the First Nation in exchange for a fee or certain other considerations. And a slight variation of service agreements are joint management agreements, in which the parties will partner to jointly manage the delivery of a service or the administration of a resource, or they will share the costs and revenues from a collaborative initiative. But again, the focus is on a specific project or a specific delivery or a specific project rather than the establishment of a longer-term relationship or collective governance. The other really popular type of agreements are relationship building agreements. These are popular because of their flexibility and typically because they're not legally binding. These are intended to be a precursor to deepening ties between communities, and they can be very vague or very specific depending on what the process of the partnership that parties wish to establish, and they can also collaborate on a wide variety of areas. So the reason why these are popular is because they can apply in a wide variety of contexts, and they're very flexible. Typically, these will announce the intention of both authorities from Indigenous governments and local governments to engage in intergovernmental dialogue and build formal relationships in the future. They will often reference things like mutual respect, understanding, and a commitment to communication, like annual meetings, and a commitment to be transparent with one another. Another agreement that has been popular in the past 5 or 10 years are decolonization agreements. These are a variant of a broader type of relationship building type agreement. And these agreements go a little bit further than the relationship building type agreements because the agreements will recognize that the Indigenous signatories historically occupied the lands, some of which are now under the administration of municipal and regional authorities. These also represent the commitment to build equal and respectful relationships between the two governments, and they may outline specific areas of cooperation or intentions to collaborate on specific areas of reconciliation. Some of which we've seen are BC, and specifically, we've seen DRIPA, which has been a highlight of the decolonization agreements. The last type of agreements that we've seen are capacity building agreements, which are very rare, but they represent a very different type of arrangement because it will commit local authorities to help Indigenous governments establish and develop their own governing structure or their community resources. The purpose is usually to create capacity for autonomy for the Indigenous government or to bridge a skill gap to provide them with training and mentorship programs. I'm going to hand it back to Professor Morse to go over some specific case studies and specific. Apologies.
A little bit more mobile than you are. So we thought we'd focus on 4 particular case studies. One, of course, included our local one here, which has been extraordinarily successful. And we look at one in the Yukon with Teslin Tlingit Council. They've got a land claim settlement with the self-government agreement that started in 1995. The village of Teslin is kind of, to some extent, surrounded by some of the lands that are now formally confirmed with Teslin Tlingit Council's ownership, in addition to what was some reserve land there. Look at the city of Edmonton, because it also creates a very interesting kind of dynamic from a big city, having the Enoch Cree Nation on its border since before the city began. Of course, the reserve there is about 8 kilometers long of a shared border. And then look at the Saskatchewan urban reserves that have come about through treaty land entitlement. And it's also something that's impacting on some other areas, including city of Edmonton. So we look at, therefore, just 4 of them, but they really are quite markedly different from each other in how they've come about. Okay. So, in fact, in terms of Kamloops, let me just say, we had the pleasure of appearing by teams this morning in front of Chief and Council to describe the project further and gain their support. They were very eager about being supportive of the project. They are happy to be, as one of the councillors said, poster child for municipal governments and First Nations across the country because it's had such a positive impact. Some of you, including me, know about the Sun Rivers real estate project that's on that reserve. There are several thousand people living there. In theory, they have a 99-year lease, but in fact, that lease term is yet to begin because it won't trigger until all of the land set aside for that purpose has been fully developed, and they're going at a gradual pace in that regard. But they've had, as mentioned, the earliest agreement from 1965 in terms that brought us the Mount Paul Industrial Project, but they've had a variety of other agreements over the years. They've had just kind of a partnership relationship with the city of Kamloops about working together in various ways and having a respectful relationship. An example of that is that in the discussions around the creation of Ajax Mine, the Kamloops and Skeetchison First Nation created a kind of community-driven process of each family having at least one member on a committee engaging in an environmental review of the safety of that project and what its impact might be, particularly on one of the lakes, which is Pipsel Lake, which is a site of significant spiritual significance to the Secwanick Nation. And the city of Kamloops waited for that process to be completed before the city of Kamloops filed and developed its final position on whether or not it would support the project or not. No agreement on that. It's just that was a respectful thing the city thought to do, to defer to the two First Nations for them to make their decision and their environmental review. Then the city would benefit from that review and make its position. So there are those kinds of just partnership things that have developed, agreement between the chief and council and the mayor and council to meet regularly. They've had a fire protection agreement since 2008. And again, in many circumstances, particularly larger municipalities have gotten government money for infrastructure like fire halls. And so we have a variety of fire halls in the city with fire trucks, et cetera, full-time firefighters. Many First Nations rely on a small fire hall or have none, and they rely on a volunteer fire department. Maybe there's a full-time chief, but everybody else are volunteers. And so for the ability for them to call upon the city is advantageous. Because also of the kind of wildfires that we've been having in the region, it's in the city's interest as well. If a fire breaks out on reserve, as we had in recent years, that the city's fire department can respond to that quickly and put it out before it spreads. So it's mutually beneficial. It's a 3-year renewable agreement, so they renew it every 3 years. It commits to Kamloops to pay an annual fee to the city, cover any overtime or enforcement costs in exchange for those fire protection services. And it committed the First Nation to pass a fire prevention bylaw that incorporates really the provisions of the city fire prevention bylaw. So again, the First Nation takes advantage of the expertise that the city has in fire prevention. That's worked extremely well for both parties. And because there's some funding coming to the city, it also enables the city to have a more robust fire protection service. A particularly recent one is the transit agreement. That was raised through community forums. It's a process where they're formed on reserve and in the city about issues of mutual interest. That came up about on reserve not having any bus service. And so it was agreed by both councils, the staff in the city that were involved in the bus service, and the agreement with BC Transit got involved and kind of leading the way with First Nation in this regard. And so that led to a partnership agreement signed in 2018 that in early 2019, by September, it was up and running, providing 3,000 hours of bus service a year, for which the First Nation contributes some funds into the scheme. But of course, it also means First Nation members are buying tickets. So the bus transit system gets more revenue coming in. So again, kind of we're a win-win. Similarly, they've had an agreement on that whatever happens to the Stuart Wood Elementary School, it's a heritage building, it's unfortunately full of asbestos. So there are challenges about what to do with it, but they agreed that whatever is done with it, they'll do it together. And so, similarly, there is a letter of understanding between the city and Kamloops that the city will preserve and promote Secwepemc values, its cultural heritage, and that they will be developing a joint Secwepemc Culture and Heritage Committee, which is now up and running. And so you may see, if you're down in Riverside Park, where there's some work underway about improving shoreline erosion. There are elders from Kamloops to Secwepemc. They're involved in all of that activity. Going to be a new walkway put through there, widening. They'll be involved in it because, of course, there are human remains on this side of the river. There are lots of cultural artifacts that people lived on this side of the river before settlers came, and so you want to make sure that those valuable, whether they're human remains or cultural artifacts, are not destroyed in the process of recreation. So the relationship has been working very well, and I think will continue to expand in new areas. Let me toss it back to Simran.
And so the next relationship that I want to highlight is the Village of Teslin and Teslin Village Council, which is located in Yukon. One of the reasons why this is a case study to highlight for us is because of the high levels of engagement and interaction that exist between both governments. So for some context, the village has about 350 people, and we have stayed in touch with Mayor Gord Byrne of the village of Teslin, who's also president of the Association of Yukon Communities and has been a huge help to our project. The village and the council have signed about 5 formal agreements from 2005 to 2011, 2 of which address relationship building and 3 of which address joint management on services, economic development, etc. All of them, again, involve high levels of engagement and interaction between both of the governments. So through our interview with Mayor Kern, one of the things that we were told is that the village doesn't do much without collaborating with the council. And it's the words that he used was that collaboration is ingrained in our DNA. The population numbers of both the village and the council and the budget differences are definitely a factor in the development of the relationship between and the agreements between the village and the council. So for example, the village's budget is around 7 million and the council's budget is around 22 million per year. So the council has a lot more power than the village, but the village has a lot more experience as operating as a municipal government, and so they're able to help the council in that capacity. But relationships and partnerships between the 2 governments were just an obvious decision for both the village and the council. So this is one of the reasons why I wanted to highlight this project, this relationship for you guys. So to start off the relationship and the formal relationship between the 2 parties, there was an infrastructure and services MOU created in 2005. This was a political accord that was meant to foster dialogue between the 2 governments. In this MOU, the parties recognized the importance of mutually beneficial relationships, and they wanted to facilitate an involving intergovernmental relationship with one another. So the MOU created a formal relationship in which the parties maintained a regular dialogue, which was the continuation of monthly meetings, which is not something that we've seen anywhere else across Canada other than Kamloops. The parties also agreed to work cooperatively and discuss in discussions and negotiations with other levels of governments to negotiate and address a variety of regional issues that included shared goals between the 2 governments. The parties also agreed to work together and to ensure that the members from both communities received a high level of service at a cost-effective pricing. So this MOU from 2005 has resulted in many joint management agreements, like a Teslin Sewer Development Agreement in 2005, the Skateboard Park Agreement, a Recreation Contribution, and Integrated Community Sustainability Plan, and many other informal agreements that continue to play a role in the relationship today. So in terms of the factors that have played a role in the success of this relationship, the council's land claim and self-government agreements were the institutions that structured the relationship because it gave the council, it armed the council with a range of powers, rights, responsibilities, and resources to deliver public goods to their citizens on behalf of their citizens. This provided both governments with a really strong incentive to cooperate. From the village's perspective, the council was this new and powerful actor in the region, and they had more funds, more power, more influence in the village. And by partnering with one another, they could receive additional resources from other levels of government and accomplish shared goals with less time, more synergy, and have way more positive outcome. When it came to resources, again, like I said, both communities are relatively small and had limited resources, but again, the council had a lot more, but they also had a lot more responsibilities and a lack of capacity in which the village came in to help with. So there was, again, a win-win for both. Both parties recognized the different dynamics that they had and the advantages that they could gain comparatively. So for example, the skateboard park agreement that I mentioned earlier probably could not have been built without the financial support from the council. But likewise, the council was very pleased to work with the village because the council members wanted the park to be built on village lands, and also because the village already had the infrastructure to manage the park. In terms of imperatives, both of the governments had really strong imperatives to cooperate and engage in deeper forms of collective action with each other. Again, like the working together increased their capacity to get work done easier by saving time, saving energy, and the significant contributions from both parties balanced together with the balancing of shared priorities, just achieved way more positive outcomes that they couldn't have accomplished on their own by using limited resources more effectively. one of the most important factor in creating this successful relationship probably was community capital. So this refers to a shared civic identity that is marked by social integration and the presence of community leaders who champion cooperation. So one of the things that we found through our research and through our interview with Mayor Curran was that community members use each other's facilities interchangeably, and there's a high frequency of interactions between the two governments. And leaders from both governments tend to move back and forth between the two governments. And so, for example, the previous village mayor was Clara Jewell, who was a member of the council for over 14 years. So this type of movement back and forth from the two governments for leaders contributes to a shared identity that leads to leaders understanding each other more deeply and results in more positive outcomes. So this relationship is just a prime example of how community capital and shared identities can generate intergovernmental cooperation and mark those relationships with high levels of engagement, more interaction, more synergy. So this is one of the most successful relationships that we've seen between local government and Indigenous governments in Canada.
Teslin's also helped by the fact that the current mayor, the village of Teslin, is now teaching at Newcastle University as well, while doing his MBA through Cape Breton University on this particular topic. So he's been great. He's excited about our project. We're excited about his master's degree and sharing. But my point is, he also has worked for Teslin Tlingit Council for a number of years before he's become mayor. So we see these kinds of relationships of communities working well, can work well, and that's at a very local level. But another aspect to these kinds of relationships is also the existence of an Indigenous population within cities. And even in the Teslin example, there are blocks of land on which Teslin Tlingit Council members live, but are surrounded by other blocks of land that are actually part of the village. And when Teslin is choosing its land, they chose some pockets of land that are surrounded by village lands, and it speaks to the comfort of the relationship that would work well. Well, in cities, there's significant Indigenous population as well as a First Nations issue. So Kamloops, for example, population is about 7,000 to 8,000 Indigenous peoples living in the city proper, not on to Kamloops to Secwepemc land. And so they are voters in the city, and so the city should be respectful of them as voters and part of their constituency. Some of whom are the Kamloops and Skishis members, but others that may be Métis or they're First Nations and Inuit. Here are some First Nations people from various parts of the country attracted in part by this university. So looking at the city of Edmonton, as I mentioned, there's been Enoch Cree along the border for many, many years. And despite that, it really took until 2004 before the two actually came to a formal agreement in which the city would provide some services to the Enoch Cree First Nation and to the reserve land in return for some payment for those services. And again, city of Edmonton, huge, got massive capacity for capital infrastructure projects, for road plowing, road paving, water lines, sewer lines, electric lines, etc. And so that benefits the Enoch Cree Nation, which has, by the way, a very successful hotel casino complex, which attracts people to the city of Edmonton, and they don't just stay in the casino, they spend money in the city. So the tourism attractions, and they have the powwow days, etc. So that kind of kicked it off. And then what you see now is a kind of explosion of agreements really over the past 10 years. And not just with Enoch, but in 2012, of reaching out to Confederacy of Treaty 6 First Nations and the city of Edmonton. Treaty 6, by the way, extends into Saskatchewan, but particularly it's the Treaty 6 First Nations in Alberta that are involved with Edmonton. But it is an open dialogue. And from the city of Edmonton's standpoint, they want to encourage Confederacy of Treaty 6 First Nations members, as well as the Confederate itself, operating within city boundaries. And they follow that up the year after, entering into an agreement with the Métis Nation of Alberta, again, to have kind of positive relationships, recognizing that many Métis people living within the city of Edmonton and many more who come as tourists or for shopping purposes, et cetera. They went back to the Cree Nation 2017 to have a broader MOU, develop expand the transit service, as mentioned in Kamloops, where they got theirs going with the Cree Nation 2018. They've followed up with a declaration of strengthening relationships with all Aboriginal peoples within the city boundaries. Most recently, they've had a draft of urban reserve strategy, and now it's moved into somewhat of a finished urban reserve strategy, and also an Edmonton Urban Aboriginal Accord last year. And what the city of Edmonton is now at a point where it wants to encourage First Nations into coming into Edmonton, not just as consumers, but also, in fact, to create reserve lands within the city. And this is something that they have learned the benefits from their neighbor next door. So let's look at Saskatchewan, treaty land entitlement. And under the numbered treaties, starting almost immediately after Confederation, when treaty making was passed from the Imperial Crown to the Federal Crown of Canada, engaged in negotiating treaties, particularly starting in 1871, in order to get BC to join Canada, because it was part of the Confederation negotiations and then did not join in 1867. There was a terms of union negotiated between Canada and the colony of British Columbia. The driver from the colony standpoint was it wanted a guarantee of a railroad connecting to Eastern Canada. And from the federal government standpoint, they promised that they have jurisdiction on railroads, but in order to deliver on the promise, they're going to have to build a railroad all the way from roughly Toronto out to Vancouver. And that, at that stage, almost all of it outside, at least from Western Ontario on, was Aboriginal title land, never was a treaty. And so the purpose of negotiating these treaties really is to open up the land for the railroad, first and foremost, and then to open up the land to attract more immigrants from Europe to come in as farmers and offer them free land if they would homestead it. And so in doing that, they negotiated these treaties in which they promised to create reserves tied to the population of the First Nation, and repeatedly failed to do so effectively. They did not count the full population. They counted when people were out hunting or trapping or away for the winter, or they were in summer camps, drying fish, etc. And so they always had an undercount of the population. This led to land claims ultimately settled in Saskatchewan and a bit later in Manitoba and Alberta, but Saskatchewan in particular was where there's a significant underestimate of it. So there's been, and under that treaty land entitlement, there was money to buy land, $440 million, but also a commitment for federal crown land and provincial crown land to be made available to First Nations to add to their reserves. So one of the things about that is, particularly for with the money, First Nations decide they want to buy land in the city of Regina, in Saskatoon, in Prince Albert, in North Battleford, and under the adhesion reserve policies, those would become reserves. First Nation would buy it from a willing seller. It applies to Canada to recognize it as a reserve. When it becomes a reserve, the land is no longer subject to any provincial law or any municipal law dealing with land matters. So it creates islands outside of the city's control and outside the province's control. There was a lot of resistance to this idea in Saskatchewan, not just in the urban municipalities, but also in the rural ones, because they lost most of the land and then they lost the tax revenue from that land. So we've ended up now with 20 known urban reserves in Saskatchewan. There will likely be more. And what happened though over the time is, despite that opposition from municipal and rural municipal governments about it, in fact, it's been extraordinarily beneficial for the cities. And hence, talking to the mayor, Simran and I talked to her in August for over 2 hours. She was eager to have more reserves in the city of Regina. It has revitalized poor neighborhoods that are now bustling. There's the new condominiums that have gone in there, and shopping facilities, gas stations, et cetera. It has transformed some of the neighborhoods in the city of Regina. Saskatoon has the same views. You talk to them, talk to the North Battleford, similar views. They're eager, in fact, because it has improved the quality of the municipal landscape and has also brought in more revenue. Now, the city gets tax money from that, but of course, all of these people coming in to shop in the city or move into the city as a result of this ends up improving the values of it. Because British Columbia is still roughly 95% provincial crown land, Aboriginal title is accepted as existing by and large in the vast majority of that space. We don't have the treaty settlements on it yet, but we can anticipate that we've got some where this has already happened on Vancouver Island, for example. We will likely see more of this happening in British Columbia as well. And as mentioned earlier, Union BC municipalities have particularly been progressive in trying to sponsor relationships between municipal governments and First Nations. But still, that's mostly, as here in Kamloops, between neighbors without there being reserves within the city. It's in a sense, Kamloops is within the city because the city boundaries actually go around it, but it's not new reserves. But we will see clearly more and more urban reserves created in smaller towns, smaller cities, and in large cities in this province as we go through the process of implementing the land claim settlements and these Aboriginal title agreements. So let me just really move right along because I know we're running a little late here. But Edmonton is eager on it, Saskatchewan's eager on it. The challenges for us as a project has been really engaging with some First Nations. I mentioned earlier we just met with the Chief and Council today of the Kamloops, although Cookie, Roseanne Casimir, is in Rome. She's part of the AFN delegation. We meet with the Pope on Thursday. But when I first wrote to her, it was just before the unmarked graves were found at the Kamloops. And that has really directed priority attention away from our little project into dealing with really not only the process of addressing those unmarked graves, but dealing with all of the legacy of residential schools and the impact it's had on members of the community and the intergenerational impact. It's also been a challenge because there is no central database of these agreements. Federal government's not involved, even in the territories, it's not really involved. The closest thing to a national NGO is really the Federation of Canadian Municipalities, but it's not involved on the ground in that sense. It is a national representative body. And in fact, Councillor Arjun Singh here is a director on the FCM. And so they developed this project with CANDO, the Canadian Associated Native Development Organization, to try and promote this kind of activity. And so that has been very helpful to us. We've had discussions with both of those parties. The project has now moved from FCM to CANDO in the lead role just in the last few months. But frankly, we have knowledge of, as you saw from some of the slides that Simran ran through, lots of these agreements out there. Getting copies of them is a challenge. And part of that, of course, is the very nature of these agreements are two-party agreements, and so you need agreement from both parties to share those agreements. And they really need to know that we're not going to be violating any confidences, and we'll treat all the information confidentially and under whatever structure or directions they give to us, but that it is really for the benefit ultimately of First Nations and municipalities, even ones that already have agreements. Nobody's got the full spectrum of agreements that are actually out there. And there are many municipal and First Nation governments who are really at a talking stage, but have yet to kind of encounter agreements. And so rather than lawyers drafting from a blank sheet of paper, we like to take advantage of this. Well, what legislation's out there, what agreements are out there, and let's learn from that. And so we're hoping that that's, again, another kind of byproduct of this project to publicize these agreements, but also learn more about them and try and do our own legal analysis of what the significance of these agreements have been to date. So that's really a summary of the project where it stands. As I say, Law Foundation is funding it. So we'll be continuing on this for at least the next year. So hopefully we'll have more to report maybe this time next year. So let me just open it up for any questions, comments, ideas, anything at all. We both welcome. So, and Emily.
In any of these agreements that you studied, was a bank ever given the ability to levy municipal fines?
Well, so long as they're reserve lands, or in the Yukon standpoint, settlement lands, then they're under the control of the First Nations government. And so hence their bylaws apply, and their bylaws, even under the Indian Act, but their bylaws or legislative instruments in the context of the Yukon, that's really legislation coming from, for example, Teslin Tlingit, or Tonquachon, or Kwanlin-Dun, or both in the city of Whitehorse, et cetera, is their legislation applies to anybody, as long as you're on their land. So if you go on to Kamloops and you're speeding, police can pull you over, they can charge you with speeding. The revenue that will go to Kamloops because you're on their reserve. If they have, minor criminal law offenses, then they can charge any of us who are there, including their own members, including members of other First Nations. If you're on their land, you're subject to their law. And so hence, all of their legislation applies to the Sun Rivers Project. They're people who are living there, they've got to obey with the terms of the project, the terms of their lease, just like any other tenant, albeit they bought the building and they have the ability to sell that building, but they're still subject to any of the leasehold requirements.
First of all, I'm very glad to see so many cases showing successful cooperations between municipalities and Aboriginal groups, generating so many positive outcomes and synergies. But as we know, Canada is rich in natural resources, and friction can occur when there are competing interests. So I'm wondering, during your research, especially when you interview various stakeholders, have you encountered any successful scenarios where parties resolve their disputes, especially over natural resources?
Well, of course, if the natural resource project is on First Nation land or Inuit land in the north, then they're in control of that. And so I've yet to experience a situation where the First Nation wants a natural resource project on its land and the local municipalities oppose it. In part because it's generally natural resource projects in Canada involve lots of land. And reserves are small. Relatively speaking, even large reserves are still small compared to the kind of territory that can be consumed. And we don't have a lot of examples where there's a gold mine just on reserve. Right? And in fact, this area, Kamloops really got going in growth was a function of gold, discovery of gold. And Kamloops Reserve ends up getting set aside where there wasn't gold. Right? And so that's tended to be the pattern. As reserves are created, at least the Crown thinks there's nothing of great value there. Right? Now, sometimes they've been proven wrong. So we have a number of First Nations in Saskatchewan and Alberta that have oil developed on reserve under the Indian Oil and Gas Canada Act. And so First Nations have some control over that development. And some of those oil fields will extend off reserve, and then it's going to be the province that's going to be controlling that. But the more common situations where the First Nations oppose to a resource development off reserve that might have that negative impact on their reserve land, or even more commonly, on their Aboriginal title lands. And so the Wet'suwet'en dispute over the Coastal Gas Link is an example of that. The Little House, a group here in Kamloops and in this really in the Thompson-Nicola Valley region that were opposing the pipeline coming through here. Those disputes still arise. The example that I gave earlier about the SSRN, the Kamloops and Skeetchison doing their environmental review in the city of Kamloops, not taking a position until the two First Nations took a position. And the city, appreciating it, would benefit from learning of their environmental report, which it did, and then the city ended up opposing the development of Ajax. Now, they didn't say they would do that beforehand. They didn't say that when they agreed to defer to the SSN review, but they were influenced by it and by the public response to all of that. So we have a nice local example where that's worked out well. But there are also BC examples where it hasn't.
Also, other examples across the country where, when it comes to dispute resolution, municipalities will tend to hand it off to provincial and federal governments when it comes to duty to consult. We've also seen other areas across Canada where municipalities don't have any dispute resolution process in the First Nations at all. So one of the things that we always look for when it comes to any copies of agreements is what sort of dispute resolution process is that for.
Thank you for the question. Yeah, sure. A great question. I'll just repeat it since it's getting recorded and you're away from the microphone. Is the question really is how are First Nations funded to be involved in these projects, and not just for the discussions, but also for the kind of key personnel that may be necessary to be involved in? Well, I guess we've got two answers to that. One is that this Community Economic Development Initiative of the Federation of Canadian Municipalities and Canadian Association of Native Development Officers, it's been funded by government as well as some internal resources, but particularly by the federal government to support that. And the nature of that initiative is that they put out a call for proposals to First Nations and municipal governments to apply for funding to develop or build upon the existing relationship that they've got. And part of the funds that are provided is to cover some of those meeting costs, and also to cover a consultant to do an evaluation of the projects. And part of the evaluation is what's been the economic impact of these relationships. So that's one way it's come. And so then, while the management is now transferred to Canada, there's still a joint partnership. They've just done another call. They were inundated with proposals. They picked 8, I think. Yeah, 8 of those joint proposals from the municipality and the First Nation. They had to submit together as partners, wanting to expand their relationship and be studied by an independent expert to come in and to kind of track what's going on and try and identify what have been the positive impacts economically, socially, etc. So that's one. The other way is the parties draw upon their own funds. So First Nation generates its own revenue and also receives funding from the federal government. The city generates its own revenue through a property tax base, but also through parking tickets and all kinds of other things. And so each of the parties, therefore, has got their own funds, and they're making the decision, this is something we'll devote money to. Mostly, they're using existing staff. So like the City of Kamloops has a person, Tammy Robertson, who is kind of responsible for citizen engagement. And that includes First Nations in the area, but also it's assisting in community meetings about the new public library that's going to be built across from Aberdeen Mall. So all kinds of things to reach out to community engagement. So part of her job is connected to this. The Kamloops is a similar situation. They're using their existing staff, and that's kind of the more common experience. But if there is a project that requires added expertise that neither the city nor the First Nations got, such as really on bus transit system, then they can turn, in that case, turn to provincial government, BC Transit, for some assistance. So money can be a challenge, though. There's some First Nations that are absolutely poor, and they've got to use the money for what are seen to be more essential things, such as social housing, healthcare, within the community, et cetera. But whereas other First Nations have got some greater capacity. But that's also where Tribal Council can step in, or like Confederacy of Treaty 6 First Nations, that they've got some infrastructure there that can be assigned to work with the individual First Nation and local government partnerships. But yeah, money can be an issue for sure. Yes.
I'm just wondering, did you actually research maybe the launches in the nature?
We haven't done the rounds yet.
But it was the most successful event in Canada. As far as the- With all the corporations, like for instance, county corporation. I'm from Saskatchewan, so that's why I thought about that.
Yep. Well, there've been a number of First Nations in Saskatchewan that have been particularly successful. And the rounds is one of them that several around PA or Prince Albert, and then around Battlefords, and then I say now, and then in southern Saskatchewan. There's some near to Saskatoon, and even some of those near to Saskatoon are opening up reserves inside the city. So we've got lots of examples across the country that say that. So Larange is on the list, but we haven't yet reached out to them.
Yeah, just that I was thinking about
So thank you very much for that.
I was hoping that with the continuing furthering of the research into the different indigenous improvements and city, is the goal to also better the relationship between communities and the province and the city moving forward?
Yeah, well, what we're doing here clearly is trying to gather as many agreements as possible and analyze them from a legal perspective, but also from the parties to the agreements themselves, trying to ascertain what's been the impact of these agreements. Are we seeing, on the ground, the relationship not only between the governments, but also between their respective residents? Has the relationship changed because these agreements exist? Because there are things to point to in which people can say, we've now got this. So we now have a bus service. That's something we always wanted. Well, now we've got it. And that's significant. And so that's come out of the relation. But similarly, for the city, what are the benefits for it? And one of the challenges, some partnerships have been more effective at publicizing the changes that have occurred because of these agreements than others. And so one of the things that the part we hope to achieve from this is to assist in that regard, to be able to bring to the public's attention. There are agreements from literally from coast to coast to coast. There are municipalities doing positive things in relation to their local population, even if there's no Indigenous community nearby. And their municipal governments are responding to both the DRIPA, the BC government's Declaration of Rights of Indigenous Peoples Act, but also now the federal one, UNDRIPA, and that's, even at the municipal level, it's got people saying, well, how does this relate to us? How do we comply with the UN Declaration of Rights of Indigenous Peoples? Likewise, how do we comply with the recommendations of the Truth and Reconciliation Commission for the missing and murdered Indigenous women and girls, two-spirited people? What does it mean for us as a municipal government? And so we see responses to that. And so hopefully we'll be able to keep kind of doing that where we're given permission. I'm hoping we'll create a national website that will contain agreements that are available for people to look at. We've talked to some municipal governments, for example, about some of these things in which they've said, we're thinking of doing a declaration or proclamation around UNDRIP. Have you got any samples for us that others have done? And so we said yes, because those were in public domain. So we passed them on to a Nuvik in the High Arctic, for example. So the more of this information you can share with First Nations and other local governments, the easier it will be for there to be more agreements. And then that just kind of, we think, will keep on rolling. And then it's, and the more you have agreements at a local level, then the more you start thinking about what other partnerships can we have. Economic development activities. How do we jointly market our region for tourism? Or how do we attract film companies, which Kamloops has some, TNRD has a person working full-time on bringing film shoots, TV shoots into the region. Well, where does the Kamloops play into that, et cetera, right? So I think we've seen dramatic growth in these agreements, but my prediction is over the next 10 years, we're going to see them skyrocket in frequency. And for us as lawyers, that means we have to anticipate that municipal governments and First Nation governments both are going to be turning more and more to staff lawyers and outside lawyers to assist in the drafting of these agreements, working their way through. Proclamation stuff is easy. It's the shared service agreements and the details of that, and who's paying for what, and what's the dispute resolution method, and what happens if payment's not made, and on, right? Because these become complex agreements and can be agreements involving millions of dollars. So we'll see, I think, a whole lot more of that going on as time goes on. And particularly in this province, because Aboriginal title is going to get settled one way or another. We've just had the Supreme Court of Canada in a case for coming out of Alberta Beaver Lake, saying that First Nations have a right to get funding. The Crown must fund in circumstances where their litigation is unable to proceed without sufficient funding. And even if the First Nation in that particular case, they have money in the bank, but they're wanting to use that money for social housing and other community needs, rather than they've already spent $3 million, I think it is, on the litigation. They're still a couple of years away from trial, and just to kind of, we can't keep spending money on this when we have urgent needs right now. So the Supreme Court can say, yep, that seems reasonable. Obligation on the Crown to ensure that if there's no agreement reached or no negotiations on the issue, then got to fund the First Nation to be able to get their day in court, not only for the First Nation, but it's in the public interest of Canadians to have these challenging issues resolved by agreement or by court decree. And so I think we're going to see a whole lot more activity in this space.
I think that one of the primary observations that we've had from the beginning is that there's no set precedent. So if you're a municipality wanting to have relationships with your neighboring First Nation or vice versa, you might not have anything to go off of, so we're a new start. So one of the main, one of our primary goals is to create a website, a database, a public one that municipalities and First Nations can both just go off of, easy to use precedents, sort of like a template agreement that you can use that just lays it out for you, does it for you kind of thing. So again, to encourage relationships, foster positive outcomes.
Any final comments, questions? Was you a question, Blair?
I'm curious, have you looked at so far, what are some of the risks that you've identified that these both of these governments, Indigenous governments and local governments, need to be aware of before we're in the process of entering into
Well, for agreements that involve fee for service, for example. So let's say the municipality is providing fire service, and it's doing that for a number of years. It's been the case here, 13 years, I think here. And the city builds up its infrastructure, buys more fire trucks because it's also providing fire service to governments. Or perhaps it builds a fire pole on the north side out on the Paul Lake Road, or on just across from the reserve. And then agreement dies. So the source of revenue is not there. So the city is perhaps at some risk in that regard. Or if the First Nation simply wants the service, continues to want the service, but can't afford the payment. And so the city could have built infrastructure or hired permanent employees, bought capital equipment for the fact that it's got a larger footprint of land that it services, as well as more residents. So there's a bit of a risk on that side. But the same thing is true from the city standpoint. If it starts to plan right now, we've got this huge project which is going forward right downtown. What, it's going to be 3,500 new residents, 2 giant high rises, and more building. City has to start planning now. Well, okay, have we got a fire hall close enough to that? For that many thousands of people now? Or are we going to need to build a new one downtown? We need to buy more equipment, hire more staff, et cetera. The city keeps growing. So there are always some risk factors here where you're kind of planning to be bigger than to service more. So, and there's, I guess, a risk factor for the city that the First Nation might decide someday to have its own fire service. But even where that exists, we find other examples. What they end up doing is agreeing to help each other, right? And that's the situation within the TNRD anyway. We have smaller communities that are relying upon other communities to provide fire service for them. And so I think, yes, there's a risk. On the other hand, as I mentioned earlier, because of wildfires, there's a risk for the city if it's not providing the fire service. So, but you make a judgment call. And of course, both from the city standpoint and First Nation standpoint, they're forming relationships between their current councillors, their mayors and their chiefs, and those people will move on. Ken Christian's been very well received by Tacamas, much more than his predecessor was. He's not running again. So what will that do to the relationship? Well, hard to tell. If there's elected as a new mayor, someone who's absolutely opposed to these relationships, well, we'll see what the council as a whole does. But their risks is these are, some cases, they're legally binding agreements, but they're time limited. So they have to be renewed. If one of the parties refuses to renew, they die. Then there'll be future elections and maybe they come back. So there, I guess in a sense, there are risks for everything. A municipal government or First Nations government, or for that matter, federal or provincial get involved in. Hard to know what the future will bring. If nothing, turn over to you, Blair. Let me thank you all for coming. For your comments, are very helpful.
Well, thank you very much, Brad and Simran, for a really wonderful presentation and a very fascinating project. We look forward to seeing it come to publication and this new website and all of the other projects I'm sure that it's going to spawn from it. So I want to just say just a couple of brief closing remarks, just primarily to thank you all for coming to the series today, the event today. And also just to let you know, this is the final research series event for this year. And so I wanted to offer a couple additional thank yous. Obviously, thank you to our presenters for today, but thank you to all the other presenters who presented throughout the year, including Professors Dia, Sykes, Stagna, Hillier, DeHand, and Prima. And to all of the RAs who have supported the work and the research of the faculty members, and in many cases have been able to present with them. It's been really excellent to see students and professors working together on this kind of groundbreaking legal research. It's really exciting, and I hope that you guys are getting some ideas of applying for research positions with professors to support more research, because you have an opportunity to get involved in this kind of wonderful work. I want to give a special thank you to Kara Karpluk, who is our special events coordinator, the Faculty of Law. She has done all the coordinating for all of these things. If it was left to me, we would probably have a jug of water and I would be holding up signs instead of having PowerPoints. So thank you very much, Kara, for all of your hard work and your excellence in putting this together. And finally, I just want to thank you. I know I already thanked you. Thank you online. Thank you to everybody who has attended these events throughout the year. Your presence makes these things a meaningful opportunity for people to be able to share and receive questions and feedback and help to create that energy that research can bring to a university environment. So thank you very much for coming. The last final note is that we have been populating a YouTube channel for the Faculty of Law with some of the videos we've been recording these lectures. So I'm not sure exactly where it is. There's probably a link somewhere on our website. I'm sorry, I don't have that ready hand, where you'll be able to find that. And next year, as we continue to do this research series, keep an eye open for that, not only to come in person, but also to be able to watch online if you miss them. So stay tuned for next year. And thank you very much. Good luck with your exams and good luck with finishing the term and finish up the rest of the baking that's in the back. All right. Thank you very much, everybody. And thank you again.
We'll also have Zoom again.
Okay.
Your
Sorry.
I'm going to Vancouver either tomorrow or Thursday. So I go tomorrow. Yeah, then I'm going.
Yeah. All right, take care.